So those two things are clear. So in terms of contract principles or causes of action, this is clear. Now, what our colleagues, and I think that was Justice Gorsuch's question, slightly different, which is, do we need to create special rules under the spending clause? Because generally speaking, if you're a prison official, you know you're working in a prison and you're bound by law to pay damages if you violate the law. Do you get an out because what? I think the consent question means what? Or notice and consent means what? And I don't know, meaning we're all presumed to know the law. When we take our jobs, the correction officers know he can't accept money. Citizens know they can't pay the money. We don't expect them to consent to that spending clause condition, do we?
I think one of the things that makes this case so much easier is that you have the consent of the person to become an officer in a federally funded program.
I agree, but I don't know why you need that. I think that's what you were saying, which is we never think of needing some express consent to say I'm bound by the law.
I think really the hard question in most of the court's spending clause cases is, can Congress impose the condition on that person? That's really the question in like Sabry. Can Congress actually impose the condition on that person? That can be a hard question, but it's not here. They admit at page 46 of their brief that they are bound by the substantive condition.
Your point is if they're bound to the injunctive and declaratory judgment relief, then they're bound to the money debt.
It's an exceedingly small step, and this court has gone—
It's not even a step.
This court has gone well beyond it, and I think you can easily get there as a matter of even just as contract principles.
Thank you.